Hi everyone, this is Pennsylvania attorney Evan Gutman presenting video number 3 of my video legal education series based upon my book, State Bar Admissions and the Bootlegger's Son. The full book, along with the supplement I wrote, is currently available on either of my 2 websites at heavensadmissions.com and gutmanvaluations.com. Those websites also contain a fictional novel that I wrote titled Heaven's Admissions Process. Kind of compares the criteria to be admitted into heaven versus the criteria to receive a law license on earth. It's an entertaining book, somewhat comical in nature. The focus of my books, as well as this video series, is on the good moral character requirement to obtain a law license, as well as other controversial areas of the legal profession and judiciary branch of government. So here we go with video number 3. Today I want to talk about the goal and strategy I have with respect to writing the book, presenting these videos. Why is this something I'm so interested in, the good moral character requirement to receive a law license? However, before I get to that, I want to tell you who my favorite U.S. Supreme Court Justice of all time is. It's a man named Justice William O. Douglas. Justice William O. Douglas, who basically in large part functions as the foundation for my beliefs on the State Bar admissions process. He wrote so many good opinions on it, as well as other areas of the law. He's a champion of the impoverished, the poor, and as a result, in my view, he's a champion and a hero. I read his autobiography years ago, I read it, and I want to read a letter that he wrote. This is a letter of former U.S. Supreme Court Justice William O. Douglas to his daughter, and it's regarding his grandson, Tyrone Wells, who is Millie's son. Justice Douglas wrote as follows. This is on December 16th, 1961. He wrote as follows. Dear Millie, I am glad that Ty is turning out to be a rebel. Any boy who is any good has that spark in him when he is about Ty's age. The problem is to see that it does not die out and that he retains the capacity to tell his old lady or his old man where to get off. The only dangerous people in the world are those who are rebels without a cause, and the problem is, as the years go by, to find a good cause to which Ty can tie his rebellion. On that, you and he can get together and come up with something pretty special, and I'm sure it will work out to the best of the order. Merry Christmas to you all. Justice William O. Douglas. It's a great letter. Now, the next is a story about me and Justice William O. Douglas. So, Douglas was a very interesting character, both in his personal life as well as professional life. He was actually married 4 times. He got married the 4th time. 4th time he got married, he was about 70 years old or so. It was in 1966. He married a woman who was in her 20s when he was almost 70, actually. She was in her 20s, and she was his law clerk, which probably would not be received too well in today's world, but nevertheless, it was acceptable back then. So, in the 1960s, when I was 6 or 7 years old, my family and I, we used to go to Puerto Rico for vacation each Christmas. And I remember, I was like 6, 7 years old, people were talking about a U.S. Supreme Court Justice who was there with a very young woman. My family was staying at the Condado Beach Hotel. Right next door to the Condado Beach Hotel was a hotel called the La Concha Hotel. And although my family stayed at the Condado Beach, including myself, each day, I would leave my family behind, go next door to the La Concha Hotel, because the swimming pool at the La Concha Hotel had a shallow end. And at the Condado Beach, the shallowest part was above my head because I was so short. And so I would go to the La Concha Hotel. And I do recall one day at the La Concha Hotel, and by the way, this is in the preface of my book, which is included in the PDF attached to this video. One day I went to the La Concha Hotel, started swimming in the pool, and there was an old guy there. And he asked me if I was staying at the hotel. I said no, I was staying next door. He said if I wasn't staying at the hotel, I couldn't swim in the swimming pool, I had to leave. Now, I don't know whether that was Justice Douglas or not. What I do know is that I told him to basically take a hike. I just literally told him off. I said, I'm staying here, get lost. Because although I knew the lifeguard had complete authority and jurisdiction regarding the swimming pool, I also knew that an old guy was not going to tell me what to do. So whether that old guy that I told off was Justice Douglas or not, I really don't know. I'd like to think when I was about 6 years old, I told off a U.S. Supreme Court justice. And if it was Justice Douglas, I'm sure he appreciated it because he had the same rebellious style his entire life. He was the only justice that I know of who was considered by both his friends and his adversaries, considered by both his friends and adversaries to be a son of a bitch. I can kind of relate to that a little bit. And I say that facetiously, somewhat facetiously. If Douglas were alive today, I'd tell him how much I admired his opinion, style, intellect, and passion for the law. So now getting to the short substance of today's presentation, since I've already given a somewhat lengthy storyline. It's about the goal and strategy. Why do I want to basically change the admissions process on the good moral character issue to become a lawyer? The problem is that lawyers are held to a lower standard of moral conduct than non-attorneys. And this is because when you apply for a law license, you're subject to a wide spectrum of overly intrusive moral character questions. But once you become an attorney, once you're in, you don't have to answer those questions again for purposes of getting a law license. My objection is that what I feel, whatever questions are asked of a non-attorney to become a lawyer should also be asked on a regular and periodic basis of the licensed attorney and judges, because otherwise it results in the non-attorney being held to a higher standard of conduct. I went through the bar admission process myself 30 years ago, 1995. Since then, I haven't had to go through it. But a person's moral character 30 years after the fact is different. People's character is probably different every 5 years. So what happens is people change over time. The manner in which I answered questions 30 years ago is not particularly relevant to my character today. And I basically didn't have a problem with it, but nevertheless, it annoyed me that I had to answer these questions. There were a lot of questions that I didn't feel I should have had to answer, and I haven't had to answer them for 30 years, but it annoyed me that I had to answer them back then. The burden of proving good moral character as a matter of law is on the applicant. However, if an attorney is facing a disbarment proceeding, in that instance, the burden is on the bar to prove bad character. Why should the burdens be different? The ethical rules of conduct that attorneys are subject to, including myself. We're all, as attorneys, we're subject to ethical rules of conduct. But the ethical rules of conduct do not penalize immoral conduct that can result in denial of a law license for an applicant. For instance, the ethical rules contain no requirement that licensed attorneys pay their debts, but applicants can be denied a law license for failure to pay debts. The ethical rules contain no limit on the number of traffic tickets a lawyer can have, but applicants literally can be denied a law license if they have too many traffic tickets. Bar applicants, unlike licensed attorneys, bar applicants can be denied a law license for being glib, facetious, obnoxious, the manner in which they left previous jobs, having a poor attitude, what other attorneys say about them, high school suspensions, unsatisfied judgments, drinking alcohol, and even most incredibly, there are numerous cases where bar applicants have been denied a law license for filing too many civil lawsuits. How you deny an applicant a law license for filing lawsuits when the very basis of being an attorney is to represent people in lawsuits is truly beyond me. My position is that if the bar makes such inquiries of applicants to protect the public, then how can they rationally justify not asking these questions of licensed attorneys on a regular and periodic basis? Because a person's moral character, years down the road, changes. I think that's all I got for today. Oh, actually, I got one other thing here. Here's a great one. There are numerous state bars, which, I'll conclude with this, numerous state bars which at one time or another have had the following question in their moral character assessment section. Get this question to the applicant. Is there any other incident or occurrence in your life which is not otherwise referred to in this application, which has bearing either directly or indirectly upon your character and fitness for admission to the bar? It is my position there is not a single person on earth that could truly answer that question fully, completely, and candidly. I mean, what do you say? When I was in first grade, I threw a water balloon at somebody. When I was 5 years old, my mother said I was a rotten kid because I took a cookie when I wasn't supposed to. Theoretically, based upon the literal language of that question, these things should be disclosed. My gosh, the average bar application, if you truly answered that question fully and completely, the average bar application would be minimum 100,000 pages. So anyway, I think it's ridiculous. I think the nature of the questions has to change. My goal and strategy is to change the bar admissions process. Have a great one, everybody. We'll see you tomorrow, the next day, or shortly thereafter. Remember, love right, don't fight. Bye.